If you were explaining negligence to someone without a legal background, what would you say? And do you think the person could decide, based on your explanation, whether someone should be held liable for negligence? Those are questions that courts face when crafting jury instructions. In Osborne v. Montgomery, Wisconsin's highest court discussed how to adequately prepare juries to determine negligence liability. 13-year-old Lester Osborne worked as an errand boy for the Wisconsin State Journal. On August 30, 1928, Osborne was riding his bicycle back to the Journal's office after an errand. Dudley Montgomery was driving his car on the same road. Montgomery stopped his car and opened his door to get out just as Osborne was approaching. Osborne tried to pass Montgomery's car, but his right handlebar hit Montgomery's door. The bicycle tipped over, and Osborne was thrown to the ground. Osborne broke his arm in the fall. Osborne brought a negligence action against Montgomery in Wisconsin State Court, seeking damages for his injuries. Montgomery argued that Osborne was contributorily negligent. At trial, the judge instructed the jury, among other things, that negligence is the lack of ordinary care, which is defined as the degree of care that an ordinarily prudent person would exercise under the same or similar circumstances. The judge also instructed the jury that someone is negligent when he or she doesn't intend to cause harm, but acts or fails to act in some way that the person should have reasonably foreseen would probably result in an injury. The jury found that Montgomery negligently failed to look around before opening his car door, and that Montgomery's negligence caused Osborne's injury. The jury also found that Osborne wasn't contributorily negligent and awarded him $2,500 in damages for pain and suffering and loss of future earnings. Montgomery appealed to the Wisconsin Supreme Court.